jurisdiction and the limits of constitutional protection. Let's take a closer look.
No one is above the law. But what happens when the law comes from an international court? After the ICC issued an arrest warrant against Senator Ronald Bato de la Rosa over killings linked to drug war, the Senate placed him under protective custody. Some say the Senate is defending its independence. Others argue it is shielding one of its own from accountability. Can parliamentary privilege override an ICC arrest warrant? Or does the Senate have an obligation not to obstruct it? Tonight, we confront a defining question. Does the Senate have an obligation to surrender Senator Bato de la Rosa?
Joining us tonight is Attorney Mel Santamaria, one of the country's most recognized legal educators and constitutional law commentators. A former dean of the Far Eastern University Institute of Law and a longtime professor at the Ateneo School of Law. Dean Mel has remained active in major constitutional debates, including issues involving the ICC, crimes against humanity, and executive accountability.
And also with us is Attorney Salvador Paulo Panelo Jr., Managing Partner of Panelo Law Office and one of the most visible lawyers defending Vice President Sara Duterte. Attorney Paulo currently serves as counsel in her perjury complaint and has emerged as a prominent legal voice in the Duterte camp's constitutional and political battles. Attorney Spaniero, good evening and welcome to Abogado.
Nice to be here.
Good evening. Thank you for having us.
Yeah, it's going to be an interesting discussion, no? Especially with everything that happened this week.
That's true. But one thing for sure, partner, we will not run out of issues as the things are unfolding before our eyes.
And before we begin, let's first look at how tonight's discussion will unfold.
We begin with the opening statements. Each guest delivers a focused 2-minute statement, laying out their perspective on the proposition. The conversation then unfolds through 2 key subtopics. For each subtopic, the guests take turns presenting their insights in 2-minute segments. Even if they share the same stand, they are encouraged to highlight different angles, supporting arguments, or real-world applications. After both have spoken, we move into the open exchange, a 6-minute free-flowing discussion where the guests engage each other directly, ask questions, and expand on their points. Once both subtopics have been explored, we proceed to closing reflections, where each guest is given 2 minutes to summarize their key messages. Finally, the hosts step in with their own questions. In this 6-minute segment, the guests respond, clarify, and deepen the discussion, ensuring critical issues are surfaced, even if the guests are aligned in position.
And now we begin with opening perspectives. On May 11, the ICC unsealed an arrest warrant against Senator Ronald de la Rosa, or Bato, for crimes against humanity allegedly committed during the Duterte administration's anti-drug campaign. That same day, tensions erupted inside the Senate after authorities attempted to serve the warrant, prompting the chamber to place the senator under protective custody. Now, my dear Dean Mel, from your legal perspective, when the subject of an ICC warrant is a sitting senator, in the case of Senator Bato, does the Senate have a constitutional obligation to surrender him or only a duty not to obstruct lawful processes? You have 2 minutes, Dean.
The Senate has the duty to surrender Senator Bato. You know, in our constitutional setup, you have the executive, judiciary, and the legislature. That is the dispersal of powers. No, the executive executes the law, peace and order, foreign policy. The legislature makes laws and impeachment trials. So nakikita na natin doon yung delineation ng poder nila. So pagdating ng pag-i-issue ng warrant of arrest at saka pagsaserve ng warrant of arrest, alam natin kung sinong dapat gumawa nun. Ang dapat gumawa nun, executive. And so therefore, kung titingnan natin, if there should be a balancing of respect, dapat na mananaig in favor of the executive because that is their job. So dapat alam na ng legislature na dapat gawin nila yon. Ngayon, ang tanong is that warrant of arrest valid, yung ICC warrant of arrest? Of course it is valid. Mag-umpisa tayo sa international law. Crime against humanity, genocide, piracy, that's international law. And our Constitution says that we accept the generally accepted principles of international law as part of the law of the land. So therefore, in 2009, gumawa tayo ng tulay, a legal bridge, and that is Republic Act 9851. 9851 says in Section 17 that kung inuusig na at iniimbestiga na ang isang taong pinaratanganan ng isang krimen against humanity, pwede nang ipahintulot ng gobyerno natin na sila na ang mag-usig at sila na ang mag-imbestiga. At kung kinakailangan, we could also deliver the suspect them. So meron yan. So remember this, Republic Act 9851 existed even prior to the Rome Statute. So even without the Rome Statute, it will exist independently. So yun yung tulay natin. And so that therefore, ang ating gobyerno can recognize an already existing investigation kasi nakalagay dun sa batas, already conducting an investigation.
So pag already na...
Yes, so
you
therefore, sinabi ng gobyerno natin, pwede na yan. So therefore, because our government recognizes that jurisdiction, then we recognizes its processes, the ICC. Kaya kung mag-i-issue pa ng warrant of arrest dito, it's a redundancy. Hindi na talaga kailangan.
Okay, thank you, Dean Mel. And you'll have time later to further discuss that when we go into our
partner,
short
very
topic.
quickly lang, yung itong dapat malaman din na nanonood, no? Itong RA 9851 na na-mention ni Dean Mel. I can even mention the senators that actually pushed and sponsored this.
Yeah.
And they are now, the same senators are actually not following it.
Like who?
Later. Suspense.
Ikaw naman, makakalimutan. Sige, dapat sabihin mo yun. Baka
Pero may
makalimutan
magagaling
natin
rin
tanongin.
noon.
May magagaling din noon.
Emphasis noon.
Emphasis. Anyway.
Okay, Attorney Paulo, parliamentary institutions are designed to protect legislative independence. But when that protection intersects with allegations of crimes against humanity, where should constitutional boundaries be drawn? And do you agree that the Senate can refuse to surrender Senator Bato de la Rosa?
Well, for starters, constitutional boundary should be drawn by the Supreme Court, not by the executive, not by the legislative. And I think in this context, in this situation, to be fair to the Senate, I think they were forced into this hand. As we know, there are pending petitions for habeas corpus since last year. We filed those on March 12, the day after the former president was brought to The Hague. And they've been pending for now almost 14 months. So the Supreme Court could have given guidance a long time ago, and this could have been avoided if they ruled on the petitions and said, this is how you execute an ICC warrant, then we wouldn't be here. But there's no guidance yet from the Supreme Court. So for us, as counsels for the petitions for habeas corpus, the government, the executive, has capitalized on this silence to propagate the same constitutional violations that they did to the former president, now to Senator Bato. It's forced, number one, the Senate to adopt Senate Resolution number 44, where they condemn extrajudicial renditions. And they've called for the protection of all Filipinos from extrajudicial renditions and to call for their right to avail of legal remedies within a reasonable time prior to extradition or surrender. So, since this is the situation and tumakbo sa kanila si Bato, they were forced into taking this principled stand to take him into protective custody precisely to allow him to avail of his legal remedies before Philippine courts. And for me, this is basic kasi the Constitution says persons are protected against unlawful arrest. And for us, that means an arrest warrant should be issued by a Philippine judge, not by an ICC warrant. So for us, this means that before an ICC warrant is implemented, it should first go through confirmation from the local court.
When we return, we examine the ICC's authority after the Philippines withdrew from the Rome Statute. Does withdrawal end jurisdiction or merely end membership? You're watching Abogado. Welcome back. You're still watching Abogado. Tonight we ask, does the Senate have an obligation to surrender Senator Ronald De La Rosa? Still with us are Dean Mel Santamaria and Attorney Paulo Panelo Jr.
Now, the Philippines withdrew from the Rome Statute in 2019. Yet, the ICC maintains that it retains jurisdiction over alleged crimes committed while the country was still a state party, relying in the clear provisions of Article 127(2) of said treaty. Meanwhile, and we touched on this earlier on, Republic Act 9851 allows Philippine cooperation with international tribunals involving genocide, war crimes, and crimes against humanity. Now, Dean Mel, and by the way, even the pre-trial chamber in its decision said that they have jurisdiction. So early on. No? So I guess that's also important to point out. Now, Dean Mel, does Article 1272 clearly preserve ICC jurisdiction? In other words, once they've acquired jurisdiction, di mo na pwede tanggalin over said alleged acts committed while they were still members? Or does the withdrawal create a constitutional and procedural gap that domestic law must address?
None.
Okay.
Because
Very categorical. Okay.
Cayetano versus Panganiban, our Supreme Court already decided the same demarcation line, March 2019. The Supreme Court said everything that happened prior to March 2019, the ICC has jurisdiction. Now let's go to Article 127. 127 provides that even if a state withdrew from the Rome Statute, it does not negate its obligation prior to its withdrawal in relation to all liabilities and crimes that has occurred prior to its withdrawal. That is very categorical. So in short, when we ratified that treaty, may commitment tayo. We know that there is a residual obligation after withdrawal. So ito yon. Ito yun yung residual obligation. Pacta sunt servanda. We have to comply with that residual obligation even after we have terminated. Now, sasabihin natin, syempre, Article 59, nakalagay doon, you have to go to the courts. Walang problema yon. Walang problema yon. But of course, the complementary provision has exceptions. If it is useless, if the local courts, if the local remedies have already been exhausted and walang nangyayari, then you could go straight to international tribunal. Anong nangyari? In November 2021, there was a request for deferral ng Duterte government for the administration. In short, the Duterte government recognized the jurisdiction of the ICC. They asked for a deferral of investigation, which was granted. But by July of the next year, sabi ng ICC, nothing is happening. Siyempre, nothing is happening kasi mga nag-iimbestiga, yung mga gumawa. So, it's talagang, so therefore, pinagpatuloy ng ICC. So therefore, yung complementary, yung Section 59 na yun, out of the way na yun. And so therefore, kaya, sabi ng ICC, doon sa kanilang resolution on jurisdiction, pinoint out nila yun. And therefore, kaya may ICC warrant of arrest tayo.
Thank you so much, Dean Mel. And later, I want to ask you more about that complementary principle in relation to Article 59 of the Rome Statute.
Right.
Attorney Paulo, what is the legal status of an ICC arrest warrant here in the Philippines? Is it immediately enforceable or even under Republic Act 9851? Or must it first go through a local court in order to be enforceable?
Yeah, our position is that it's not enforceable immediately. You have to go through the courts as required by Article 59 of the Rome Statute itself. And this coincides with our constitutional requirements that before you arrest somebody, you have to comply with the requirements of Article 3, Section 2 of the Constitution. A judge should determine personally probable cause after examining witnesses and so forth. So for us, you can't automatically implement a warrant of arrest. And I recall that while the last year, when there were discussions on the petitions for habeas corpus, the DOJ position was that RA 9851 gives it two options. One, extradition, which requires it to go through the local courts, and surrender, which they deem the executive option. But as we've all established today, the RA 9851 was passed with the Rome Statute in mind. The Rome Statute wasn't signed yet, but the deliberations will show that that was the design. It was supposed to put a bridge to the Rome Statute, to the ICC. So if surrender is actually a technical term. Extradition is a technical term. Extradition means transferring one person from one country to another country. Surrender means transferring a person from one country to an international court, specifically the ICC. And this is defined in the Rome Statute itself. So when you say surrender, it only means that you have to comply with the rules on surrender, which Article 59 says you should promptly bring this person before local judicial authority first, before you go to surrender.
Okay, thank you so much, Attorney Paolo. And tamang-tama, now we're opening this
Yes.
for discussion. And I wanted to connect yung where we ended when it comes to Article 59 of the Rome Statute, where it does say there that when you have a person being arrested in a custodial state, that you have to bring them to a local judicial authority, which us lawyers would interpret to be our local courts.
Yes.
But Dimel, you mentioned that because wala na yung principle of complementarity,
Wala na talaga.
then
There is none.
bakit hindi na applicable yun? So like for example,
Because-
we are, if we say that the Philippines is not willing and able to prosecute the crimes against humanity that is the subject matter of this case, then bakit magiging baliwala na rin yung Article 59, which still clearly states that you have to bring the person arrested to a local judicial authority?
Because we've already exhausted all remedies under the local jurisdiction. Ang complementary law is to give a chance to domestic law to exert their kind of justice. But wala na eh. So, wala na eh, because at that point in time, humiling na ang Duterte administration ng deferment so that sila na mag-investigate. But absolutely nothing happened. Nag-follow up ang ICC, walang nangyayari. I'm sure wala talaga mangyayari doon. Kasi yung Duterte administration, ang inimbestiga sila rin eh. So, therefore, you could see the uselessness of it all. So, kaya nga, pumunta na sa ICC. Ngayon, ang punto ko, the crime against humanity, genocide, piracy, they are customary international law. And in international law, there are four sources of international law: treaty, customary international law, general principles of international law, and statements of well-renowned authorities. There is no hierarchy. They can exist together, they can exist independently. So even if wala yung Rome Statute, RA 9851 directs itself to customary international law. And as a matter of fact, it could exist independently. Number two, yung sinasabi na the judiciary sets boundaries. Of course not. The Constitution set boundaries. That's why we have respect. Basta't ginawa ng executive, we give great deference to the executive's action. Basta't ginawa ng legislature, we give deference to the legislative action as well as the judiciary. So makikita natin ngayon, hindi nag-issue ng TRO. Hindi naman ibig sabihin na porkit walang express provision ng SC. Walang mangyayari. Silence is also a signal that something can be done.
Yeah, your point on customary international law, erga omnes, no? Crime
Correct,
against humanity. Yeah. Siyempre, palatin-latin term din kami dito para that's how we justify our legal fees. By the way.
Inaantay ni Attorney Mike kanina pa yan. Gusto kong gamitin itong Latin term na to.
But yeah, you said that, no? Na yung complementarity principle. Do you agree though? Do you agree that there was really failure? Because that's the only time it applies, no? Na hindi na mag-apply yung provision na yun, is when it is shown that the local courts, the local jurisdiction can no longer function as such. Is it true? Do you agree with that?
Well, I recall that at the time, the Philippine government was being represented by Solicitor General Guevara.
Maynard,
and
yes.
I read their submissions, and they had proof that they had over 300 ongoing investigations and
So it was
court
functioning.
cases. So that was their proof that, hey, we're doing our job. You shouldn't meddle with our process here, with our laws, with how we want to punish these crimes. So I don't agree that the investigations were going nowhere. I mean, for example, Kian de los Santos, or, diba, na convict yung mga pumatay sa kanya. Now, if you're talking about something, a case similar to what was filed there, which in the ICC, which comprises of like a systematic design for the drug war to do extrajudicial killings, then they should file one here. The complainants should file one here, and I'm sure that the Marcos government is will very willingly pursue this, because ngayon, as we know, magkalaban na sila sa politika. So there's no reason why the Philippine government should not assert its sovereignty and its power to look into these crimes and prosecute them. Yun lang.
And on that point, Dean Mel, sige, para sabay mo nang sagutin. Di ba nag-issue din ng subpoena ang CIDG to Senator Bato de la Rosa in relation to their own investigation on EJK killing. So kung ganun ba, would you still say that under this government, there's a failure to prosecute?
Okay, let us contextualize. Yung kay Ian de los Santos, who are these people? They are like you and me, ordinary people. Look at the crime against humanity kay Duterte and all the co-perpetrators. Sino sila? They are big-time people with power at that point in time. Do not compare Ian de los Santos with his powerful people.
But he's a victim,
Okay, number
diba?
one. Yes.
Victim si Kian.
Right.
Oo.
So therefore, you cannot. That is also contextualizing complementarity. Who are the people? What did they do? How much power do they have? Does the system allow redress of grievance against these people? Siguro kay Ian de los Santos pwede, pero kay Duterte, sino gagalaw kay Duterte noon? Wala. Ngayon, you have to contextualize it is not a simple case of looking at a provision and interpreting it in isolation. You have to contextualize. Number two, jurisdiction is already attached. Bato has already been declared a co-perpetrator. Nandiyan na yan. And we cannot relinquish jurisdiction ganun-ganun lang. We saw the confirmation of the charges ni Duterte, and in the dispositive portion, nandun na sila. Nakalista na sila, black and white. So, it's useless talking about this because nandun na si Bato as a co-perpetrator.
So, Dean Mel, the only part I don't agree with would be yung principle of complementarity as a reason to disregard the requirement of the Rome Statute when it comes to enforcing an ICC warrant of arrest, because it is part of the Rome Statute, Article 59, to bring an arrested person in a custodial state before a judicial authority. Tapos nandun din yung mga steps that they have to make sure or validate that this is the same person named in the warrant that is being arrested. So, para sa akin, ibang issue yun sa complementarity. Complementarity is what gives the ICC the power or the jurisdiction to investigate, and therefore pursuant to that, to issue the warrant, and therefore, when you're already enforcing, then you follow the steps under Article 59.
Another angle is probably Article 59 is no longer applicable because we have withdrawn at this point in time. Kaya nga ito yung sinasabi ko, that Republic Act 9851 can stand in itself because it is connected to customary international law. And when you talk about customary international law, then you can talk about crime against humanity. Kasi nagiging stricture international law must be applied in a very progressive and liberal way. Kasi basta ginawa mo yung crime against humanity, ang hirap talaga manghuli. It is so hard to capture a person who was so powerful. And as a matter of fact, that has been reflected in the affirmation of jurisdiction. Sinabi, we cannot let Duterte go kasi sa Pilipinas, ang laki pa ng kanyang financial, political influence. So if you look at decisions, they are deciding it in a certain context, not in isolation. Di ba?
Okay. Attorney Paolo, a quick rebuttal.
Well, RA 9851, based on the deliberations, is supposed to apply to an international court that has jurisdiction. Kasi nga, di ba, when it came out, hindi pa tayo party to the Rome Statute. So, may discussion doon, including Senator Kiko Pangilinan. Somebody asked him, I think it was Senator... One senator was asking, what is the net effect if we pass this law without becoming a party to the Rome Statute? Ang agreement nila is, wala, we cannot transfer jurisdiction to a court that has no jurisdiction, that walang applicable treaty. So para sa akin, since we've already withdrawn, we're talking about now arresting somebody and delivering him to a court that no longer has jurisdiction on us, edi wala nang saysay itong Section 17 RA 9851.
I don't agree with that. Alam mo kung bakit? Kasi sinasabi nga natin, no? The origin of a law is intention. The perfection of the law is its expression in the statute. Tingnan natin ang Section 17. Napakalinaw. We do not need the deliberation to tell us what it means. Napakalinaw kasi kung kung inuusig na sa ibang bansa, pahintulutan na natin at kung kinakailangan, ibigay natin yung accused. What's ambiguous about that? The deliberation will only be considered if ambiguous ang statute. It is not ambiguous.
Okay, talaga napaka-interesting ito. Tama ka ata, partner. Bitin ang magiging one episode for this.
Ako, sir,
Okay,
just one short rebuttal. Ang ambiguity is, the proof of that is that it's taken the Supreme Court now 14 months deliberating on this issue.
over
Wala
a
pa.
year na.
That
So,
is
yun na nga.
silence. You cannot infer from silence any ambiguity. Maybe it's just the usual tardiness of the Supreme Court, but you cannot impute
But
anything
Dean,
from that
this
silence.
is a writ of habeas corpus.
You
It's
cannot
supposed to be
impute
summary in
anything
nature.
from silence. You cannot impute something that is against public policy from silence. That is absurd.
Oo nga. Okay,
Okay.
sige. Talaga interesting, no? Kasi
Exactly.
dapat nga, di ba merong mga timeline to decide habeas corpus cases.
Exactly.
But, okay, thank you so much, attorneys. We'll definitely talk about this more. Up next, parliamentary privilege and Senate custody. When does institutional protection preserve legislative independence? And when does it begin to obstruct justice? You're watching Abogado.
Welcome back and thanks for joining us. You're still watching heated debates only here in Abogado. Now, we turn to the constitutional powers of the Senate itself. Article 6, Section 11 grants lawmakers immunity from arrest only for offenses punishable by not more than 6 years imprisonment. Prison correctional, if I'm not mistaken, no? Crimes against humanity under RA 9851, on the other hand, carry penalties far beyond that threshold. Still, the Senate placed Senator De La Rosa under this concept, which up to now I do not understand, concept of protective custody after ICC-linked arrest efforts inside the chamber.
This raises difficult constitutional questions. Is protective custody a valid exercise of institutional authority or an unconstitutional shield against lawful arrest? Dean Mel, does parliamentary privilege have any constitutional application here at all, given the gravity of the alleged offense and the penalties attached to crimes against humanity?
Absolutely none. This parliamentary privilege is totally without basis in law, without basis in the Constitution. Kung sasabihin natin, this is traditional, no? But you cannot weaponize tradition and make that tradition as the means to give a person who just committed a crime against humanity a sanctuary. Hindi pa pwede yun. Hindi mo pwedeng gawing hideout ang ating gusaling ng Senado on the basis of tradition. Kaya absurd talaga yon. There is none. it is that building is for public service, not for Senator Bato. Di ba? Hindi pwedeng maging ganun eh. Kahit na ano tingin mo doon, there is absolutely no basis.
Well, thank you very much, Dean. Kagaya ng sinabi mo, yung building na yun, tinayo naman para sa mga public property yun eh. So it's not supposed to protect anyone. Anyway, that's another topic altogether. Now, Attorney Paulo, where does the Senate derive the power to place one of its members under protective custodies? And if authorities are serving a warrant, can preventing access amount to what you call obstruction of justice?
Right. No, I agree with Dean Mel that they're not supposed to do that, or they don't have the power to do that under normal circumstances. But again, as I said earlier, this is not normal circumstances. This is a situation where, for the first time ever, an ICC warrant was issued, one first against a former president and now a sitting senator. And we're still lacking guidance or waiting for guidance from the Supreme Court. So, as I said, I feel like they were forced into this hand. And they're not asking, they're not protecting Bato from facing accountability. They're simply asking for Bato, Senator Bato, to be given his legal remedies. As the Senate Resolution number 44 said, reasonable time prior to surrender to avail of and exhaust his legal remedies before Philippine courts, which is recognized by Article 59 of the Rome Statute anyway. So for me, it's a principled stand. It's justified, but normally, wala talagang kapangyarihan na ganyan. As far as the obstruction of justice is concerned, I saw the press conference of Senate President Alan Peter Cayetano this afternoon, and he said that despite promises from the NBI, the actual ICC warrant, as transmitted to the PCTC, hasn't been presented to the Senate. So as far as they're concerned, while their position is we will only recognize a local warrant, even the ICC warrant itself hasn't been presented. So their position is, and I agree with them, that there's no obstruction of justice by trying to prevent the service of this warrant or the arrest of Senator Bato.
Okay, so since we finished both of your statements here, we now will open this again for another discussion. But I'd like to throw in the views that were also exclaimed or expressed publicly. Like, for example, DILG Secretary John Vic Remulla said that the ICC warrant of arrest that Senator Trillanes or former Senator Trillanes was holding in the Senate is an unenforceable document. And in the past, in last year's arrest of former President Duterte, when there was a Senate hearing afterwards that was conducted, then Justice Secretary Boying Remulla said that the government still does not recognize ICC jurisdiction and that their basis for the arrest was the Interpol red notice and our obligations to the Interpol. So, given that stand of the government based on their statements, their public statements, it appears that in this case, kaya hindi napigilan si Senator Bato de la Rosa na umalis from the Senate or kaya siya prinotektahan din ng Senate is because as far as they're concerned, there was no valid warrant for them to allow Senator de la Rosa to be arrested. So, yung question ko, for example, yun yung mga naging statements ng government at ang position nila. Dean Mel, kung meron namang RA 9851 or even if we can use the customary law as our basis to say na enforce yun na yung warrant na yun, bakit hindi na lang maging clear ang ating gobyerno about that?
The government was very clear. Kung napakinggan natin si Department of Justice Polo Martinez kaninang umaga, he was saying, we have all along says that Republic Act 9851 was our basis. So saan nyo nakukuha yung walang position ng government? Kung sinabi yan kanina, express it just today, May 14, 2026, Polo Martinez categorically stated our position all along was Republic Act 9851. And he is speaking, and he is with the Department of Justice. And we should give deference and great weight to a spokesperson of the Department of Justice. Kung nagkakalabuan man tayo, doon tayo papaling. Diba? So wala, there is no problem. There is no problem. Kaya I cannot see where that's coming. Hindi ko makita kung saan nanggagaling yun dahil meron naman categorical stand ang ating gobyerno.
Paulo.
Ako, sir, speaking of DOJ spokespersons, actually, si DOJ spokesperson, Miko Clavano, at that time, nung inaresto si Pangulong Duterte, ang sabi niya, ang basis nila for arresting the former president is Article 59 of the Rome Statute, at ang DOJ daw ang competent judicial authority. Yun ang posisyon nila nung bago namin i-file yung petition for habeas corpus. Pagka-file namin, biglang nagbago ng tema, RA 9851 na. So that's number one. Number two, tingin ko kasi dito, gustong i-recognize ng Marcos government ang ICC, pero hindi sila maka-turn back because nung magkakampi pa sila ni Duterte, ang pronouncements nila clear. Hindi namin rene-recognize yung ICC, hindi kami makikipagtulungan dyan. So biglang napasok yung Interpol. They said they will cooperate because of our obligations to the Interpol. But what did we find out during this petition for habeas corpus? What we found out was that the arrest warrant from the ICC was emailed from an ICC email address to Interpol Manila. Now, Interpol Manila, sino ba yan? That's the PCTC. In other words, mga empleyado rin yan ng Pilipinas. Hindi yan Interpol officials. It was just a request from an ICC email address to Interpol Manila composed of Philippine officials. So even their excuse of complying with Interpol obligations is not true. It's a farce. Hindi yun totoo.
Ang punto dyan, ang huling punto dyan, authentic ba yung dokumento? Kasi kahit
sa ICC.
Oo, kahit saan manggaling-galing yan, kahit anong pumasa-pasa dyan, basta't ang hinahawak mo, authentic na document, it solves everything.
But I have a question. Sino ba dapat ang nag-enforce ng ICC arrest warrant? Because the visible figure last Monday was former Senator Trillanes, and that's why on the plenary of Senate, people were asking, is he already the process server for the ICC? In general, sino ba? Meron ba dapat representative from ICC na dumadating?
In this particular case, it's the Department of Justice. Remember, the NBI is under the Department of Justice. Kaya yung puntong yan, wala nang problema yan, basta't ma-serve yan. No? So it's a government entity, that is the representative of the government, and it is so useless for anybody to even, create confusion on that. Basta't DOJ, NBI, sinerve niya, gobyerno yan, ayos na yan.
Okay, Attorney Paulo.
Who should serve it? For me, it should be somebody from the government, number one. But ang mas importante dyan is dalhin mo sa korte. Diba? Actually, yung dadalhin sa korte, dapat nga mauna muna yung arrest warrant from a local court bago mo dadalhin sa korte. Tapos, dun mo i-discuss ngayon yung validity ng ICC warrant. Yun ang tingin namin. Because for us, Dean Mel has said RA 9851, customary international law, pero for us, of course, Constitution remains supreme in the Philippines.
Teka muna, tingnan natin ang Konstitusyon. Ang sinasabi mo ba yung Bill of Rights?
Yes.
Ang sinasabi mo ba na walang warrant of arrest, no warrant of arrest should issue unless by a judge?
Yes.
Di ba? Qualified ba yung judge? Hindi naman eh. We cannot distinguish what is not distinguished, di ba? Nakalagay doon, judge.
So you're saying local judge or foreign judge?
Of course, because ang gumawa tanda natin, ang gumawa ng 2009, Republic Act 9851, hindi mga pangkaraniwang senator to. Sila Miriam Defensor Santiago to. Sila Juan Ponce Enrile to. Sila sagisag to. I could not even pretend that I am better than they. Ibig sabihin ko, nakita na nila yan. Kaya ginawa nilang tulayan, Republic Act 9851, diyan sa ating, sa crime against humanity, so that nakita na nila, kung may judge na nag-decide na may probable cause, okay na rin dito. You cannot interpret the Constitution in a vacuum. You must interpret the Constitution in the light of what is happening today. Otherwise, parang ang Constitution natin, a statue in a museum. Walang hindi gumagalaw.
Well, sir, with all due respect, diba, judicial power is vested in the Supreme Court and such lower courts that may be created by law. Obviously, ICC is not one of those. Diba? And,
Oh, no, I disagree. Because nga, that is, Republic Act 9851, precisely, we recognize an international
hindi po.
tribunal.
Well, kasi po, tiga mo, actually, tinignan po din namin yung basihan ng pag-issue ng warrant of arrest. Para lang i-compare sa constitutional requirements natin. Yung mga ginamit na basihan to issue the warrant of arrest and to deny the interim relief request were Rappler articles, newspaper articles, hearsay evidence. So, sa atin po, hindi po papasayan.
Teka muna. Nabasa mo na ba yung Estrada versus Ombudsman? Sinabi ng Korte Suprema, in the level of preliminary investigation, hearsay is acceptable.
Yes, pero dapat corroborated, Your Honor.
Tingnan natin ang ginawa ng ICC. Substantive evidence ang level nila. Substantive evidence, mas mataas sa probable cause. So it was a finding of the judges there, 3 pang West.
Pero hindi po Pilipino. Yun ang pinaka-importante doon.
Kasi ang ating konstitusyon, sinasabi, judge lang, pwedeng Pilipino, pwedeng hindi. At precisely because yung Republic Act 9851, nire-recognize natin ang jurisdiction ng International Tribunal.
Okay,
I
talagang
disagree.
kulang ang request ko
Kailangan
dito
to
magka-part
part two.
2. Kasi
Part two.
mauubusan na tayo ng
Yeah.
oras. But thank you so much,
Yeah.
attorneys. Hindi pa naman tayo tapos. When we return, closing reflections on our central question. Does the Senate have an obligation to surrender one of its own? This is Abogado.
Welcome back, and you're still watching Abogado. And for those who just tuned in, unfortunate for you because you just missed really a very heated but intellectual discussion on this particular issue. Now, from ICC jurisdiction and treaty withdrawal to parliamentary privilege and Senate custody, tonight's discussion has tested the constitutional limits of accountability itself.
At the center of the controversy is no longer only Senator De La Rosa. It is the larger question of how democratic institutions respond when international criminal law reaches the political establishment. We now ask for closing reflections. Dean Mel, your final statement.
Well, we just witnessed what happened in the Senate. And what happened in the Senate is a manifestation of everything that is sick in the system. No. We saw, for example, tradition being weaponized to give sanctuary to a person suspected of committing a crime. We see, for example, accountability being viewed as an attack. And we see, for example, right or wrong being submerged to loyalty. And we see, for example, it mirrors, what happened mirrors a feudalistic mentality where you have to associate yourself with power to be able to get justice, not innocence. Diba? So nakikita natin, bakit tayo na-frustrate? Why did we feel disappointed and frustrated? Kasi nakikita natin, ang powerful, pinoprotektahan ng powerful. Diba? Ang isang malakas na tao, pinoprotektahan ang isa pang malakas na tao. Dapat pabayaan na lang natin si Senator Bato. PMAyer yan. Kaya niya na ang sarili niya. Bakit pa natin kinakanlong? Iyon ang nakakainis. That is the psychological effect sa mga taong nanonood. Kaya kayo at ako, naiinis. Bakit ganon? Dalawa ang klase ng hustisya. Basta't pala may connection ka, ang galing, nadidelay ang administration of justice. Pero kung ikaw ay pangkaraniwang tao, kulong ka kaagad. That's the point. That's the whole, that is the message of what we witnessed last night. It's a feudalistic, it's what is sick in the system. Talagang it mirrors it mirrors justice which is not there, but only they're wrapped in complexities which only the rich and the powerful can navigate. Basta't hindi ka powerful, hindi mo mananavigate yan kasi wala kang pupuntahan. Iyan ang message kagabi.
Attorney Paulo, your closing reflections.
Yeah. So, for me, it's not about evading accountability. It's about asserting sovereignty. The point is that a Filipino accused of committing a heinous crime against fellow Filipinos in the Philippines should be decided based on Philippine law, Philippine rules of evidence, and by fellow Filipinos as judges. We shouldn't outsource our justice to strangers, to our system of government, our evidence, our culture, and the harsh realities that shape the decisions during the drug war. Wala akong bilib sa mga banyaga. I've been following the ICC because I need to, because of the petitions for habeas corpus. Wala akong kabilib-bilib. Kasi nababasa ko yung mga decision nila, napakababaw, yung ebidensyang ginagamit nila, napakababaw. Hindi yun papasa dito. At alam ko na merong bad reputation sa publiko ang judicial system natin. I'm here to tell you, I'm not a veteran lawyer compared to Dean Mel, of course. I've been practicing for close to 15 years, and I can tell you that 90% of the time, the judges here that I encounter are fair. And they rule based on evidence, they're not influenced, they're not compromised. So that's why I'm still practicing. Kasi kung ang punto pala natin is wala tayong mapapatunguhan dito sa justice system natin, di ba? Hindi na ako magiging abogado. Pero proud akong maging Filipino lawyer because I know while our system is imperfect, it's working. So para sa akin, dapat dito linilitis si Pangulong Duterte at saka si Senator Bato.
Okay, thank you so much, Dean Mel and Attorney Paulo. And a few seconds na lang, partner, I'll give you the opportunity for your own closing statement. Sino yung mga senators na nag-draft ng RA 9851 na sinasabi mo hindi sinusunod ngayon?
Masasabi ko lang, mayroon akong selective amnesia.
Pinaasa mo kami, sabi mo, sasabihin mo mamaya. Okay, our thanks to Dean Mel Santamaria and Attorney Paulo Panelo Jr. Hahanapin ko na lang yan sa deliberations. For helping us navigate one of the most consequential constitutional questions facing the country today.
Because in the end, the issue is not only whether international law can reach a sitting senator. It is whether democratic institutions remain accountable when power itself is under scrutiny.
And in a constitutional democracy, the rule of law is tested most, not when it confronts the powerless, but when it confronts the powerful. This is Abogado. Good night.